At the risk of sounding like I'm making a pun, it's a judgment call. When you file for bankruptcy protection, if there is a lawsuit pending against you, that lawsuit will be stayed. And that's because whenever you file a bankruptcy case, the act of filing the petition triggers a stay. You don't have to do anything else, so it's called the automatic stay. In law, by the way, a stay is saying stop. Whatever stayed has to stop immediately. So in this case, what stayed or stopped is all action by creditors against you as a person, against your possessions, against the bankruptcy estate that's created, excuse me, when you file the papers. In practical terms, it means they can't call you on the telephone, send you bills, write you letters, sue you, garnish wages, seize money out of bank accounts. And if they're doing any of these things, they have to come to a halt. So if it looks like the kind of debt that we're talking about here is of the dischargeable variety, then out of a courtesy to the creditor, you might want to go ahead and file the bankruptcy sooner rather than later so that the creditor doesn't end up spending a lot of money unnecessarily getting a judgment that would never be collectible anyway because of the bankruptcy discharge. The wrinkle is if it looks like the debt could be of the non-dischargeable variety, then if you file the bankruptcy case, you might end up having to defend two lawsuits simultaneously, one in the California Superior Court and the other in the adversary proceeding that the creditor files in the bankruptcy court to challenge the discharge of the debt. But for the most part, it's probably not the deciding factor on when you file the bankruptcy case. There are other issues in pre-bankruptcy planning that may be implicated, but whether the judgment has been entered or not is probably not that important if the debt's of the dischargeable variety.